Well, I was in the legislature, and in 1970, the legislature passed the Family Law Act of 1970. This was the first change in the divorce law in California in the history of the state. And no longer were you using things like alleging mental deficiency, criminal conduct, loathsome disease. We went to a term that would cover everything. And unbeknownst to me, I made a great contribution to the legal effort in California, and it wasn't until years later when a film came out by the name and people started to use the phrase as an everyday phrase that I realized what I had contributed as a throwaway line was in fact very significant. When bills pass in the legislature, in the two houses, the Assembly and the Senate, they must be identical. If one comma is out of place, the bills go to what is called a conference committee. And the conference committee, made up of 3 members of each house, 3 senators and 3 assemblymen, would iron out the differences. Then they would be approved by both houses and go to the governor for his signature. So there were some points that were in dispute between the Senate version and the Assembly version. And the conference committee is traditionally chaired by the senior Senate member. In this case, it was Senator Don Grunsky of Watsonville, chairman of the Senate Judiciary Committee. And I was serving on the Assembly Judiciary Committee, and I was appointed by Assemblyman Jim Hayes, who was chairman of the Assembly Judiciary Committee, to go to this conference committee. So there we were, 3 assemblymen and 3 senators ironing out the differences. When we got to the place as to what to call the grounds for divorce, Senator Grunsky says, I want a neutral, no fault term, and I don't want to use the word no fault. So they're throwing out different versions and so forth. They have absolutely no interest in this subject. I'm sitting in the back of the conference room, which was a long table and senators on one side and assemblymen on the other side and staff. And I'm looking at my watch because I want to catch the afternoon PSA flight from Sacramento to Los Angeles because I had things to do in Los Angeles. And I've contributed nothing to this discussion. So they're going back and forth with different terms and so forth. And I throw out, in a casual, unthinking way, what about irreconcilable differences? And Senator Grunsky says, I like that. And of course, when the chairman of the committee says, I like that, the staff guys are writing it in the bill to be printed and so forth. And so they put it in the bill, and it passed both houses. Governor Reagan signed it into law, and the basis of our divorce law in the Family Law Act of 1970, which went into effect in January 1971, was irreconcilable differences. If you alleged irreconcilable differences, you could be granted a divorce by the courts. Some years later, some lawyer practicing in the field of family law came up to me, and he knew the story, and he said, you know, there have been 146 appellate court decisions trying to figure out what the legislature meant exactly by irreconcilable differences. And there wasn't anything. It was just a throwaway phrase to get out of it. Now they made a movie on it. They use it all the time. The irreconcilable differences has become an essential piece of California law.